What's going on, guys? Welcome back to the channel. This will be a remake to my last video, which is the debunking of the Certificate of Non-Citizen Status, Non-Citizen National Status, including debunking the American national concept, where both of those things that I just mentioned would apply to someone born in one of the states of the Union, right? So people like Brandon Joe Williams, Joe from Freedom Fighters, David Jose, or whoever else who promotes this has been selling you straight up garbage. And I'm going to debunk what the fuck they're saying right now, all right? So to start, I'm going to be speaking about 1452, Certificates of Citizenship or U.S. non-citizen national status. Part A, of course, applies to one who is a citizen. Part B applies to what we're looking for. But I want to read a couple definitions first. So I'm going to go literally 1101, Title 8, right? So this applies to Chapter 12. So as you can see, as used in this chapter, they don't say title, chapter. That means Chapter 12. We scroll down to number 22. It says, the term national of the United States means one, a citizen of the United States. That's one. They give you a term, but they don't give you a definition. Or B, a person who, though not a citizen of the United States, owes permanent allegiance to the United States. Okay. They did not give you a term. Instead, they gave you a definition. So that means they could be they could be one or a variety of classes of persons that would qualify under that definition right there, since they did not give a term. So that's important to understand, that this right here is a definition and not to a specific category, not a specific people, persons, group, or whatever else. All right, that's important to understand. Section 1452, Part B, it states, a person who claims to be a national but not a citizen of the United States may apply to the Secretary of State for a certificate of non-citizen national status upon one, proof of satisfaction to the satisfaction of the Secretary of State that the applicant is a national but not a citizen of the United States. And two, so this is an and. Two, in the case of such a person born outside the United States, they want their oath of allegiance. So this right here is an and, only in conjunction if the person was born outside the United States or its outlying possessions. They want that oath. The same one as if it's for naturalization. The individual shall be furnished by the Secretary of State with a certificate of non-citizen national status, but only if the individual at the time within the United States or its outlying possessions. Right? So for those who believe that the term United States in this context means some type of corporate entities, right? Then your logic is already flawed, right? When you're using this process, because then you're admitting that you're within that corporate structure, that corporate whatever jurisdiction that people talk about, instead of the physical location, the landmass of what it is. That's one, right? The one thing I want to point out here is this, that this is important. National, comma, but not a citizen, comma, of the United States is a term in and of itself. This right here is a class of persons. The question you should be having is, where is it defined at? Since it's not under section 1101. Since we know we're under chapter 12 of Title 8, we have to have definitions either from another title that reference this section for those definitions, or that definition is here within Title 8, Chapter 12. So let's see if we could go find it. Section 1408, of Chapter 12 of Title 12 is called nationals, but not citizens of the United States at birth. It says, unless otherwise provided in Section 1401 of this title, the following shall be nationals, comma, but not citizens, comma, of the United States. That means this right here is the substance, not what something is called. So if you are one of these things right here, this under these provisions, then absolutely you have every right to go file for one of these certificates. But now I want to go deeper into this. Since right here they tell you that it's under Title 3 of the immigration, right? In this case, it's 66 stat, right? That's an amendment. All you have to do is go look. So in 1986, right, this is where they changed. They added to Section 1452, meaning 1452 only used to be Section A. Section B did not exist until 1986. So let's see what they did. What did they amend to 1452? Section 16. Section 16A, Section 341 of the Immigration and Nationality Act, codified at 1452, is amended by what? 1, in the heading, by inserting, in quotations, or U.S. non-citizen national status after citizenship. Let's go see if they did that. Well, look at that. After citizenship, they wrote down or U.S. non-citizen national status. What else did they change? By inserting quotations A after Section 341 and by adding at the end of the following new subsection. Now, this is in quotations. This is literally what we just read. B, a person who claims to be a national, comma, but not a citizen, comma, of the United States may apply to the Secretary of State for a certificate of non-citizen national status, and the rest we already read. So this did not exist until 1986. But for me, I still want to know who these classes of persons are. The only way to do that is to go to the Immigration Act itself. So the provision where it gives these people power to hand out these certificates is at Section 502. 502 and 341, like they just stated, what they just amended. But they amended the whole of 1452 and added the non-citizen aspect. Here is the original law, the original statute that grants them the power for such certificate. The Secretary of State is hereby authorized to issue in his discretion and in accordance with the rules and regulations prescribed by him a certificate of nationality for any person not naturalized citizen of the United States who presents satisfactory evidence that he is an American national and that such certificate is needed for use in judicial or administrative proceedings in a foreign state. They even go further that the certificate shall be solely for the use in the case for what it was issued for, and shall be transmitted by the Secretary of State through appropriate official channels to the judicial or administrative officers of the foreign state in which it is to be used. That means you don't even fucking get it yourself. So here they're describing American nationals. You guys understand, this ain't about citizenship, so I can't go to Section 341. I have to go to where they're giving certificates of nationality, and they're describing American nationals under the Immigration Act. So the question for me would be, who are American nationals at the time of this act in 1940? Well, let's go look at this American Law Review, or Fordham Law Review. They're going to be using court cases and interpretations and terminology that coincides with the Immigration and Nationality Act of 1940. And I'm not even going to go far into this. 52 pages, but all I need is this one page to shoot people in the face. Not directly or intentionally, right? But this right here is a shot at them for what they have misconstrued, misinterpreted, or blatantly just are giving you false information. It says, as this article explains, American national status occupies the space between citizenship and alienage, and thus is a distinct category itself. On the one hand, the law treats its holders in some ways as if they are U.S. citizens, having acquired American national status based on birth in a U.S. territory. What did they just say? Having acquired American national status based on birth in a U.S. territory, American nationals owe allegiance to the United States and thus are categorized as members of the American polity. The Immigration Act does not apply to them because they are not aliens, so they don't have to do naturalization procedures. They have U.S. passports and accordingly do not need visas to enter the United States. Additionally, American nationals are not subject to deportation laws because U.S. territories are part of the United States. Not in the constitutional sense, but for sure statutory and so forth and treaties. Yet, on the other hand, the law treats American nationals as non-citizens by virtue of their alienage. They are not ineligible to vote in a federal, state, and local elections. They are unable to serve on a jury and bear arms. Moreover, they are excluded from certain federal and state jobs. Now, it's impossible for us to be one of these things. Just by these denials on rights, because their rights are statutory only, not God-given, not fundamental or anything. Although millions of people who were born in U.S. territories acquired after the Spanish-American War of 1898, Guam, the Philippines, Puerto Rico, American Samoa, and the Virgin Islands have held this status, very little is known about it. From the historical relic, non-citizen national remains the status of the people who are born in American Samoa today. What year is this? This year, I think, is 1913 that this document was written. But I'm going to read the annotations, number 9. Number 9, C 8 U.S.C. 1101A22, which is what I read. Defining a national of the United States as a person who, though not a citizen of the United States, owes permanent allegiance to the United States. Sean Morrison, Foreign in Domestic Sense. And this is a book that he wrote. American Samoa and the Last U.S. Nationals. 41 Hastings Constitutional Law, 2013. Like citizens, nationals are part of the American polity, but they do not have all the same rights and privileges. U.S. nationals may apply for certificates of non-citizen national status, see Section 1452B. However, the U.S. Department of State has since declared that those eligible for a certificate for a certificate shall instead apply for a U.S. passport. And they give you the government website to go look at. But the key here to understand is what they're saying here. They're giving you constitutional law. They're giving you court cases. They're giving you things that you need to find out if what I'm telling you right here is bullshit. But they flat out tell you, having acquired American national status based on birth in a U.S. territory, American nationals owe allegiance to the United States and thus are recognized as members of the American polity. Additionally, American nationals, no, not that part. This part. Far from historical relic, non-citizen national remains the status of the people who are born in American Samoa today. There's no other information that would in any way state that American national applies to one born in one of the states of the Union. Outside of what you give it, meaning you create the definition for the paperwork that you're writing. This right here is blatant. That does not apply to anyone born in the state of the Union. The fact that the term that they're using in Part B of Section 1452, the term national, comma, but not a citizen, comma, of the United States is a term in and of itself is another whack to the dome for that. So for Brandon Joe Williams or Joe for whatever, right? Joe from Freedom Fighters or David Jose, right? They never broke down this section right here. The interpretation of this. They for sure, in my eyes, are not true law researchers. They go with whatever sounds nice to be able to promote the crap that they promote and sell to you. But the definition is clear right here. The following shall be nationals, comma, but not citizens, comma, of the United States. And for me to add something to this, I'm going to add passports to this video. There's only two classes of persons that could get a passport. Let's go see who they are. A U.S. national means a U.S. citizen or a U.S. non-citizen national. Now, without going into the definition of U.S. citizen, right? Let's look up what U.S. non-citizen national means, since people want to get a passport under this. It says it means a person on whom U.S. nationality but not U.S. citizenship has been conferred at birth. Under what section did they just say? Section 8 U.S.C. 1408. Or under law or treaty. The law or treaty. The law would be the territorial law of that territory. The treaty is, of course, the thing that Congress makes between that foreign nation and itself. So no other law cannot mean some shit that people want to make up and say, yeah, it applies to those born in the States of the Union. They flat out told you right here that a U.S. non-citizen national has derived nationality specifically from Title 8, codified at 1408, which is the same thing for what? National, comma, but not a citizen, comma, of the United States. So to each their own, when it comes down to it, you have to make a determination if the person that is telling you these things is correct. Is his interpretation correct? Did he commingle definitions? You know what I'm saying? Like, what is it that they're doing to try to make their point across? You have to go and research that. Don't let them tell you. Go and force them to tell you where they're deriving this terminology from, the definitions from. Because I swear they don't know. They do not know. But to each their own. I hope to get some commentary, and for sure, share it with those 3 people that I mentioned. Brandon Joe Williams, Joe from Freedom Fighters, and David Jose, or Jose David, however he's called. And ask them the same questions that I'm laying out here, because I don't change up nothing. The next one I'm going to be doing is a beatdown on Brandon Joe Williams, his website. He commingles definitions here. He commingles definitions from Title 8 for the word person, right? Because it also means an organization under Title 8. And he uses that definition and takes it to Title 22 and now says that because a person is an organization, that means that a organization or corporation could get a passport. 100% commingled definitions. 100%. Right here. In Title 8 of the code, right, person is defined as a person means individual organization. The term individual is not defined and is not specifically defined and thus defaults to a dictionary definition. So even though he could do this, because he's forcing a definition to mean something in what he believes it means. He's not letting the information take him to the meaning. He's forcing it, right? So now he uses Black's Law Dictionary to go along with this. As you can see by the definition above, it also includes artificial persons, right? Organizations. Or the definition in Black's Law, or include artificial persons. Then finally, we have the term organization. And from Title 8 definition, the person, right? The term organization means, but is not limited to, an organization, corporation, company, and so forth, right? So now he goes, this is pretty wild, by the way, because organizations could get passports. He's reading Title 8 and saying now they could get passports. They are persons under Title 8, which is all about nationality. Yeah, all about nationality, not about passports. It's the basis for the passport system. But you could literally open a company in the District of Columbia, which would make it a U.S. citizen under 8 U.S.C. 1401, and that's bullshit too. Get an EIN number, and then go do a DS-11 to get a passport for it. 100% incorrect. 100% commingling of definitions to topics that do not apply. Title 22 have their own definitions. The only time Title 22 reference another title for definitions is what I just stated right here. U.S. non-citizen national incorporated the definitions for Title 8 under Section 1408. That guy, 100% in my eyes, is a fraud. He misinterpreting shit on purpose or whatever, right? Or goes in assuming a definition, and then everything he reads, he tries to force it to his original definition for his process, for his theory or opinion could make sense. That's commingling. You can't do that as a law researcher. You have to let what you're reading take you in the direction that it's going to take you. Let it take you to the meaning of those terms. Outside of that, straight garbage. I hope for some commentary and some feedback. Let me know what you guys think. Have a good one.